Good evening, everybody. Welcome to our Protecting Your Legacy Through Conservation-Based Estate Planning Landowner webinar series. We're very happy that you took time on this very cold and chilly January evening to join us. In fact, when Guthrie and I were thinking about dates for our webinar series, we decided January would be a pretty good date for a webinar, given that it's oftentimes just nice to snuggle in at home. So thank you for joining us. My name is Paul Catanzaro. I'm a professor at UMass Amherst in the forestry program and serve as the state extension forester. Guthrie Diamond is a graduate student working with me and has been hugely helpful in helping to organize and pull off this webinar series. I want to acknowledge up front our sponsor, Massachusetts Department of Conservation and Recreation, their service forestry program. The service foresters work directly with private landowners. They can provide free technical assistance, come out to your property, answer questions on the phone or online. They implement the current use program, Chapter 61, as well as the Forest Cutting Practices Act and the cost share program. So they're an excellent resource for forest landowners, an excellent first call to get information, and they have a program called their Forest Work Initiative, which encourages active forest stewardship with private landowners. And they recognize that the average age of landowners in Massachusetts and across the country is increasing. And the decisions that you all make about the future of your forest, the future of your property, the future of your land, will be the driving factor of what public benefits the land provides in the future. So they provide this funding in the hopes that we can help inform your decisions to plan the future of your land. So we thank them for their support. This is a 4-part webinar series. We had our first webinar 2 weeks ago on January 13th. I talked about conservation-based estate planning just in general, what it is. We talked about setting goals for the land. We talked about asking 2 important questions, sort of getting started. If you missed that or you're interested in seeing that, the recording to that, as well as the recording to tonight's and the future webinars, will be on masswoods.org/webinars. And I'll put that link in the chat when I'm done talking here, so you can go and see that. We'll be talking tonight about passing on your land using wills and trusts with our friend Peter Zomack. Get to that in a moment, but just want to let you know the third webinar will be on permanent land conservation tools. Olivia Lukasik from the Trustees of Reservations will be joining us, talking about what those tools are. If you're interested in keeping land permanently, some or all of your land permanently conserved, she'll be talking about that. And then our final webinar on February 24th, which is a new one for us, is meant to reach those people that may be owning land in the future. So if you have sons or daughters or heirs that you're likely going to give your land to, invite them, encourage them to come. We're going to be talking about what it is to own land and some of the basics and try to ease that transition for those that may not have experience with land ownership. I just want to make sure I repeat this disclaimer. It's wonderful. We have so many people. We had 385 people sign up for this webinar, which is absolutely wonderful. And it is a pretty broad geographic scope, as you can see. And this isn't even all the states, but this was most of them. So this is a pretty broad geographic scope. Like my presentation at the last webinar, much of what is talked about tonight, the general information, is likely relevant to you. This webinar, however, because the legal aspects of it in particular, is likely to have more state-specific nuance to it. So you will probably hear us say a number of times, please, check that or talk to an attorney or representative, a legal representative in your state. But I think much of what we talk about tonight will be relevant, and hopefully, as is the goal of these webinars, to empower you, to give you information, to give you some confidence, to help you understand who to go to, maybe what kinds of questions to ask. Our hope is that you will pursue estate planning and that you will reach out to someone local, whether you're in Massachusetts or Colorado. So just one review slide for those of you that were here last time, and if you weren't here, that's fine. I understand and I know that estate planning can be a complicated topic, and in fact, sometimes it's so complicated people don't want to deal with it. And so one of the tools we've used over the years to help people start breaking this down into more bite-sized pieces is just asking two important questions. The first question is about ownership. Do you want to determine who owns your land after you? And if that answer is yes, then the next step is what tools can you use to actually transfer that land? And that's much of what we'll talk about tonight. The second question that we'll be dealing with in our next February 10th webinar is, do you want to decide what will the future use of your land? So do you want some or all of it to remain undeveloped in its natural state? And if that's the case, there are tools that can help you reach those personal and financial goals in terms of that future use. But tonight is about future ownership. So if you do want to, there are legal instruments that and ownerships that can help you transfer the land to the person that you are interested in, and in a way that maximizes your goals. So tonight we're very fortunate to have our friend Peter Zomack here with us from Zomack and Zomack. He works, and he and his wife Meg work in Amherst. Peter has been helping families engage in estate planning for decades. He's been helping people for decades with their tax planning, and he's been involved in land conservation for years and years. So I'm very pleased, very fortunate that Peter agreed to come and share his experience and his knowledge. I have a piece of paper and pen out because anytime I listen to Peter, I always get lots of new good information. So with that, Peter, I'm going to stop my share and hand this over to you. Thank you very much for joining us, and I look forward to your comments.
Well, great. Thanks, Paul, and welcome everyone. It's nice to talk with you tonight. I hope that I will give you some good information and motivate you to really think hard about planning for the future of your own land. One of the main things to keep in mind is that don't put this off. Whatever you think you don't know about where this land is going to go, come up with a plan and know that it can always be changed. And if you don't plan, then it's a very difficult situation that often arises for your family. In particular, if there is no will or no trust, then the laws of your respective state, what these are called the intestacy laws, which means dying without a will, they will govern where your property goes. And that doesn't mean the property will go to the state, but they will go to family members that you may not want the land to go to. It may work out just fine. It goes to your surviving spouse or to your children, but not necessarily. So the main thing is to get something down on paper, whether it be in a will or a trust or some other instrument. And I always tell my clients, whether it be, passing their land down or passing their millions down, let's get it done and then, review it from time to time, and you can change your mind, or you can become unhappy with someone and take them out of your documents or add someone new. But if you die and haven't done anything, then sometimes it turns into a real quagmire for those that are left behind. And I will sprinkle in a couple of client stories as I go that are true stories. I'll obviously keep the names out of it, but sometimes unexpected things happen that make things difficult, not only for the family but for the lawyer who's involved. Um, so there are several ways to pass your land to the next generation or to other folks that you would like to get it. And the first one in my presentation is through a will. And everyone sort of probably knows what a will is, but it's basically a very um, relatively short document that says, upon my death, this is what I would like to happen to my personal property, meaning my clothing, my jewelry, my tractors, my cars, all the things that I can touch. And then what happens to the rest of my assets, meaning land, real estate, or bank accounts, investments, and those sorts of things. And a will can be a couple of pages, it can be 10 pages, it can address all of those different assets. And the key thing to know about a will is that it needs to clearly identify where your property is to go. So if you have, 10 acres of farmland and you want that to go to a certain child, you need to name that child. Or if you want it to go equally to two kids, then you would say in equal shares to Jim and John. And it can be in percentages as well, but it's really got to be very specific, so that there's no question about who's going to get it upon your passing. The other important factor that I've run into from time to time is that we don't indicate backup beneficiaries. So, in other words, if you left your property to me and I die, there's no alternate beneficiary listed. And that's not necessarily a problem because it would go to the people that are named in the residue of your will, meaning the people that get everything else that isn't specifically mentioned. But if you don't want those people to get the land, you need to have a backup to Peter Zomick. It could be, my brother or my sister or my child or whoever you want, but I always encourage people to say, I'm giving this land to Peter, but if he predeceases me, I'm giving it to X. So it's really important to think about sort of not just today, but what if somebody dies who's in that will? Let's make sure that I've got a backup person to receive that property. Um, another thing that we've run into from time to time is that you leave land to someone in your will and you don't specify how they are to own it, meaning in Massachusetts and in other states that you guys are in, land can be owned a couple of different ways. One is joint tenants with rights of survivorship. And that means that if Paul and Guthrie own a property together with as joint tenants, if one of them dies, it will pass to the other as the surviving joint tenant. But if we leave the property to Paul and Guthrie and we don't say anything about survivorship, it's presumed, at least under Massachusetts law, that it passes to them as what's called tenants in common, which means they own 50% each. And that's fine, except if your intent was for the survivor to get the property, and Paul dies, Paul's share does not go to Guthrie in the tenants in common situation. It goes to his own heirs in his will or trust. So if you have a survivorship situation that you want to address, again, you need to say so in the will. What else is there to know about a will? Well, one of the big factors is, which you may be familiar with, is that a will must go through the probate process in Massachusetts or any other state. And that means the process of the probate court in your county reviewing the will and approving its language to make sure it has all the necessary particulars. It was signed properly, it was witnessed, it was notarized, and the judge of the probate court will determine whether that will is acceptable in the Massachusetts or New York or wherever you are. That process is formal. There are 5 or 6 different forms, at least in our state, that get filed along with the will, listing who the heirs are, who the executor or personal representative is, and so forth. That process takes roughly a year in Massachusetts. It used to take a lot longer, but they've streamlined the process a little bit, but it's still a long time. And usually you can't do this probate work yourself. So you're going to hire someone like me and or the family is and spend some money in that process. So a lot of people consider other vehicles, which we'll get to in a minute, rather than a will because it's less formal and it takes less time. And a lot of people read about probate and say, I want to avoid probate no matter what. I don't want that delay. I don't want my kids to have to go through the formality of it. And I don't want them to wait so long to inherit the property, whether it be land or cash or whatever it is, by having to go through the probate process. So that's one reason that people like to avoid passing land through a will because it takes a long time. The other issue is that it can be contested. So if I leave my farmland to my oldest son and my youngest son is has been expecting that land all of his life and all of a sudden he doesn't get it, well, he can file with the probate court to contest my will after I'm gone. And he can, say that either the will was fraudulently signed, that I was forced to sign it by someone, or that I was incapacitated. No comments on that, Paul. When I signed the will. So if the will can be attacked in that way successfully, then my youngest son may end up getting the land, even though I didn't necessarily intend for him to get it. It's very rare and it's very hard to successfully contest a will, but it has happened in my practice two or three times over the 30 plus years. Um, Even if it isn't a successful challenge, it can be very damaging to family dynamics and sort of, addressing how the land is managed and held in the future because there was a big fight to start off, the situation after someone has passed away. So yet another reason to think about a trust because a trust is much harder to challenge, at least in Massachusetts, because it doesn't go through probate in 99% of the cases. The other thing which I threw in here at the end of the will section is you could consider a deed with a reserved life estate to pass your property. It's not one of the big categories that I've addressed in the other sections, but it's a thing that's more commonly used these days, mostly with a home, but it can also be used with, farmland or forest land that you may have. And the way this deed works is that I would deed the property to my son, reserving the right for me to have ownership for the rest of my life. That's the life estate portion. So my son's name is Kevin. Kevin gets the property upon my death in full, but he has an ownership interest today because I've put his name in this deed. So I have the right to use the property for the rest of my life. He can't kick me out and he can't sell the property without my permission. Similarly, I can't sell the property without his permission. We all have to agree, any life owner and remainder people, the people that will own it after me, must approve any sale. What does this do? It, first of all, avoids probate because a life estate, which ends at my death, is an ownership interest that I have, but it ends at my death, and my son, in my example, has a remainder interest. Those two ownership interests together mean that that property can pass outside of the probate process in Massachusetts. It goes to my kid directly upon my death. He has to just record a death certificate, and my life estate ends. It also provides tax advantages because my life estate is considered an asset of mine and includable in my taxable estate when I die. That doesn't mean there's going to be any estate tax. It just means it's potentially taxable. And because it's potentially taxable in my estate, my son will get the property at what's called a stepped up basis or date of death value. So he gets the property at whatever it's worth when I die. Contrast that with a deed where I just give him the property today. If I give him the property and I don't have that ownership interest, he gets it at my original purchase price, which means nothing if he doesn't sell it. But if he wants to sell it, he could have a very large taxable gain because I bought the property, 30 years ago or something like that. So that's a very common technique. There are some cons to the life estate, one of which is that remainder person, my son in my example, is now an owner of the property. And so if he gets into trouble, meaning he gets sued, he files for bankruptcy, or he has a car accident, or is divorcing, my home or my land, farmland, family land, is an asset of his now. Even though he only has a partial ownership interest until I die, it's an asset of his that could be attached by a creditor of his. So that's something to think about before you do a life estate deed. And the other issue is that, it's a little bit more complicated because we have multiple owners. Um, it's a great tool for a home to also remove it from your estate for long-term care planning. It's not really the focus of today's discussion, but it's something that we see a lot these days because trusts are not as effective as they used to be for that type of planning. So, something to think about as an alternative. I don't like life estate deeds with many, many beneficiaries. I prefer it with one or two kids or grandkids, mainly because all of a sudden they're co-owners of a property. And again, we have that go back to that issue of are they tenants in common or are they survivorship owners? You have to be very careful in structuring that. Um, I have a situation now where mom gave her home to her two children, reserving a life estate. Mom is 101 and she has outlived one of her children that she deeded the property to. That child lives in New Jersey, didn't have a will, and her estate now owns an ownership interest in that property. So we're going to have to find a way to probate in New Jersey and then in Massachusetts in order to pass that survivorship interest, which really hasn't even come into existence yet because mom is still living. It can get very complicated. So you just have to be careful with that type of ownership. Um, Another example that I have with regard to a will is a farmer in a local town in his will left his property to his four children, which included a dairy farm and many acres. That was at least 20 years ago now, and the family is still trying to figure out what to do about it. There's one child who farms the land and runs the beef cattle operation and so forth. The rest of the kids have no involvement, but they have not given up their interest yet. And they continually say that they will, but nothing has happened. So the farm operator is sort of hamstrung because he can't do a lot when there are three other owners who really have a lot of say in whether a bank will finance the property, whether they can sell the property, whether they can put a conservation restriction on it or anything. So a will is great, but you need to whatever you use, will, trust, or other arrangement, discuss it with your family and be really full open book about what your plans and goals are so that everyone knows about it and can say whether they're on board with it or not. It's your decision, but the kids, if they're going to own it, should have a little bit of ability to say, hey, I'm not comfortable with this, or I would prefer that, Joe gets the land and I get some of the cash so that we can be equal, but that won't hold him up from doing what he needs to do. I have no interest in the land, so give it to him and let me have some other asset if there are such assets. So I think communication is really important. Um, and the final thing I'll say about wills, but it applies to trusts as well, is that I had a Hadley farmer several years ago say to me that he didn't need to do estate planning because he wasn't dead yet. And so that goes back to my first point of, do the plan as soon as you can and then think about revising it later. But don't, hold back because, you're feeling good now and you've got a lot of life to live. I think it's important to set up your plan and be comfortable with it, digest it, and then change it if you need to. Moving on to trust, which is section two of the presentation. A trust is also a legal document which is created by you to hold title to your land or to other assets, whether it's bank accounts, investments, any sort of thing like that. The only thing that doesn't generally go into a trust is retirement assets or life insurance. So liquid assets can go in and land can certainly go in. You generally would be the trustee of your trust for as long as you can be. So, as long as you're competent and alive, you can usually be the trustee. It could be you and your spouse, it could be you and your kids. It's important that you name backups so that if you become incapacitated or die, there's someone who can step in to be that successor trustee. Usually it's a family member or a close friend that if you don't have family members who are appropriate, if there's no one else as an individual that's available, you can use a professional trustee, such as a bank. In our area, there's only one bank that does that, but in other areas, there are many trust companies or banks who can be professional trustees. Naturally, they will charge a fee, but they can manage land or other assets in the trust for your benefit. But usually you're the trustee because you want to maintain control of your assets while you're alive, while you're alive, and then ultimately have a successor to manage this property after you pass. There are several different types of trusts. The most common is the revocable trust, which is the one I just mentioned, where you're the trustee and you can make changes anytime you want to that document while you're alive. In addition, there's an irrevocable trust, which we see sometimes for estate planning, where someone wants to immediately get an asset outside of their estate, either for asset protection or to avoid estate taxes. Not as common as it used to be now that the federal estate tax exemption is large. In Massachusetts, we have a $2 million estate tax exemption, and in some of these surrounding states, there's no estate tax at all. So it's less important to do trust planning for tax savings reasons. Any asset that's in a revocable trust will avoid probate, which again, a lot of people are very focused on that. And that means we save time when you pass away and we save expense because you probably, in most cases, the family doesn't need to hire an attorney to help them navigate the trust after you're gone. So it's faster and less expensive with a revocable trust or other type of trust that's owning your land. I mentioned here a testamentary trust, which is a trust that's created inside a will. I don't see them very often for land transfers or transfers to adult beneficiaries, but oftentimes we'll see them for minor beneficiaries. So if you're doing a will and you have children who are under 18 or 21 or 25, whichever age you might pick, you can designate that if they're under that appointed age when I pass away, I would like this land or these assets to be held for their benefit in a trust that's created inside my will and only if it's needed. It can also be used for disabled beneficiaries or someone with perhaps substance abuse issues or things like that. So less common, but we'll see them often with young families. And young families are often farmers, so there could be land that's held for the benefit of minor beneficiaries for a number of years. But it's important that you have a trustee who you can trust to manage that property for the benefit of the trustees until such time as they're able to take it themselves and take on the ownership. The trust, whatever type it is, will say that the property at my death passes to my intended beneficiaries in the trust, whether it be children, grandchildren, or other people, or it's passing to them at the time that they reach the required age if they're younger. Um, and it's a really great vehicle for making a little more detail about how the property is to be managed. You can sort of expand upon things a little bit more in a trust than in a will. So I see a lot of people using these. You still need to be specific about who's going to inherit through the trust, how is it going to be owned, and again, what if that first person passes away? Who's the intended beneficiary if they're not around? The last type of trust, which we don't see very much out in this part of the state, but it's still common in Eastern Mass, and occasionally we'll see it as a nominee trust or a realty trust. And this is an ownership vehicle as opposed to an estate planning vehicle. So we really won't use those when we're planning how we pass land down to the next generation or to other friends or family members. It's really just an ownership vehicle as opposed to a full trust. So it's almost it's called a disregarded entity in terms of going forward. So what that means is that the beneficiaries of a nominee or realty trust are in fact the owners. The trust is not an owner in that situation. I list here some pros and cons about trusts. And as I said, excuse me, it's excellent for succession planning and probate avoidance. You can keep land or other property in the family for multiple generations, although usually we'll see a trust ending at the next generation or perhaps one below that, just for management purposes, because a lot of people say, you know what, once I'm gone, I want my family to figure this out themselves and do some planning of their own for the family farm or the family timberland or whatever it is. It's flexible. It can be changed if it's a revocable trust. You can change it anytime you want. You can bring people in as beneficiaries. You can take them out. Depending on the size of your estate and the value of your land, it's good for estate tax savings as well. There isn't, under the cons, there's no liability protection with a revocable trust. So, in other words, if you have property in a trust, it does not shelter that land from any kind of creditor that might be suing you. So, we'll get to limited liability companies in a minute. Limited liability is not available for a trust. So, any trust property, it's open season on creditors or divorcing spouses or other issues like that. Um, it's a little bit complicated in administration after you die, but not nearly as complicated as a will. Um, and I mentioned income taxes. They're not relevant with regard to land per se, but they are relevant for income that might be earned from the land, like rental income, for example, or timber income. If that income is in the trust and it's not distributed to the beneficiaries of the trust, trust tax rates are very, very high. And it's not so much that the rates are high, but that the brackets are very compressed. So whereas we might reach our highest tax bracket as individuals at 300,000 or something like that, a trust reaches the highest tax bracket at about 14,000. So the takeaway there is if you earn income, a trust earns income, you want to make sure you distribute it to the beneficiaries of the trust so they can pay tax and not have the trust pay tax. Sometimes banks will give a landowner a hard time if the property is owned by a trust, but that's becoming less prevalent as banks are understanding that lots and lots of people are using trusts for estate planning. As I mentioned before, a trust can last for more than one generation of beneficiaries. But the problem is if those beneficiaries are not going to act as trustees, who is? Is it a bank? Is it a younger family member? If it's going to last for 50 years, there may not be a trustee around. So you need to have several layers of backup trustees picked so that the beneficiaries can choose a trustee. We usually craft it that way, but it's a lot better if you get to be the one who controls who the trustee is for a number of years. Um, and then it's often used for a couple of different reasons. One, where we want to have intergenerational transfers to kids, grandkids, and so forth. But I also see it where folks want to sort of try to rule from the grave by administering a trust so that, hey, this is who's going to be the owners beyond my debt, beyond my life. And that trust, which is revocable while I'm alive, is irrevocable after I die. So my kids or whoever it is who are the beneficiaries of this trust are they're going to be stuck with whatever I've designated unless they find a way to sort of break the trust. But hopefully you've set it up in a way that's you're happy with, and that the rest of the family is happy with. And as I said before, you discuss it with them that you have full disclosure so they're aware of, what you've done and why you've done it. And anyone who has an issue with it can sort of express those issues before it's too late, before you're gone. Um, Moving on to a partnership, this is a vehicle that many of you may have seen if you have family farms or other businesses. This is a less formal vehicle than a corporation, but it can be oral, but I'd never recommend that. It should be a written document which says that we are forming this partnership to own our land, manage our land, and it will also often contain provisions for what happens when the partnership partners die or want out. So we need to address what is the exit strategy? How is the exit calculated so that I can be cashed out if I don't want to be a partner anymore? Or if I die, and my partners don't want to be partners with my wife because she doesn't know anything about the business that we're operating. How is she going to be cashed out? And that can be in a lot of different ways, but it needs to be addressed in the partnership. In addition, the partnership agreement needs to say, how do we manage this? Who's the partner that makes decisions, or are there multiple partners that have a say? How are the profits split? I have one partnership now where each year they actually change the distribution of profits based on how much work each partner does. It's not a farm or anything related to land, but they sort of have their own side job or regular jobs, and the partnership is their side gig. And so each year, one partner or another is contributing more to the profitability of the partnership, and they split their profits accordingly. A partnership is quite easy to set up. Again, it needs to be written. You can allocate profit and loss, as I just mentioned, as often as you want to. I see it fairly often for family farms who want to keep things relatively informal. Um, Usually, we'll see people go to an LLC, which we'll discuss later, because they're concerned about liability, particularly if you have farm equipment or if you have people visiting your farm to pick vegetables or fruit, or you have other profit activities that people are coming onto the property for. An LLC makes more sense because a partnership does not provide any liability protection. It's unlimited personal liability, which is listed under the cons below. Um, Family limited partnerships are a specific type of partnership, which gives you the ability to value the interest in the partnership when someone dies and obtain valuation discounts for those ownership interests. Not very common anymore because the federal estate tax exemption is now 15 million. Back in the day when the exemption was only 600,000, I saw a lot of people setting up family limited partnerships, so I don't really get into that too much. Um, and since I'm a tax guy, I always try to mention some of the taxation, and partnerships are a pass-through entity, meaning that the partnership reports its own income on a partnership tax return, but does not pay any tax on that income. All of the income is passed through to the partners, and each of the partners reports that taxable income on their personal tax return or loss, depending on whether it's a profit or loss. As I mentioned, you have unlimited personal liability for any lawsuits that are filed against the partnership. The partners can be exposed. It's really important to have a written agreement that's hashed out between all of the partners because I've had a couple of situations where it ended up in litigation because they sort of did things on a shoestring agreement and then handshakes, and they had a falling out and things didn't work very well after that. Um, Oftentimes, if you're borrowing money to do improvements on your land, the banks that are involved will not be happy with lending money to a partnership. They want to have personal guarantees from the partners. That's not usually an issue, but just something to be aware of. Um, and what are they used for? Well, certainly farming together with either brothers, sisters, father and son, mother and daughter, or even multiple generations. It's a great vehicle where we can set up partnership interests with the older generation, perhaps having a larger share of the ownership, and then gradually transferring ownership to the younger generation as they get more involved. And the elders want to sort of phase out. We will see that happening. So we'll see gifts between the parents and children or parents and grandchildren. And it's very easy to do and doesn't involve any state filings or anything like that. So there's no particular formalities there to worry about. Um, it's, I think it's a good vehicle, but it is less formal, and the liability issue can become something that's a deal breaker, and people then turn to LLCs, which are the next thing on the list. An LLC is a limited liability company. It's very much like a partnership, except it has that shield of liability protection, meaning that assets that are owned by the LLC are subject to creditors. So if someone sues my LLC, they can come after the assets that are in the LLC, but they cannot come after my personal assets. There's a shield protecting my personal assets. Even though I'm an owner or a member, it's called, of an LLC, no one can come through the LLC and get after my personal assets. And that's as long as I follow the formalities of an LLC, which are very few, but basically you have to file an after creating the LLC, you have to file an annual report every year, whether it be in Massachusetts or New York or wherever. All of the states have this requirement that you file an annual report and you indicate who the members are and the manager is and what the business purpose of the LLC is, and you pay the fee, which in Massachusetts is $500. So it's not inexpensive to file that annual report, but as long as you do that, you've satisfied the formalities in Massachusetts and protected the LLC and maintained that sort of force field that is between you as a member and the LLC itself. So the big pro of an LLC is strong liability protection. And other than that, it's very similar to a partnership. You have an agreement, which is called an operating agreement, which says we're creating this LLC for this purpose to manage our farming operation, to manage our forest management business, whatever it is, maple sugar, you name it. Um, and we are the owners. Here are some particulars about how we're going to buy out a member who would like to get out. Here's some more information on what happens if an owner dies or is disabled. How are they bought out in that way, or how are they compensated? All of those things are outlined in the operating agreement. Um, they're very flexible. They are managed by you as members generally, or you can hire a manager who's not a member. It's up to the members to figure that out. The taxation is exactly like a partnership. So the LLC does file a tax return, but it does not pay taxes on its own. It flows the income to the members of the LLC, and they will file report that taxable income on their personal tax returns. Um, it's very easy to remove members or add them. As with a partnership, you can have the senior members of the family be majority owners or majority members, with younger members being minority members for as long as you want, and then you can eventually transfer so that the older owners actually phase out. Um, I see a lot of operating agreements that have some significant restrictions because people want to keep the business or the farmland or whatever it is in the family and restrict who can buy that property. So we will have specific language about who can purchase or not purchase. And oftentimes there's a right of first refusal that, direct family members can buy out. If I want to sell my interest, all of my siblings have first right of refusal to buy my interest so that my interest is not sold to someone who's not in the family. On the downside, There aren't many. The fees are, to some people are significant. It costs $500 to sign up for an LLC in Massachusetts, plus whatever you pay a lawyer to create it. Um, in Massachusetts, interestingly, you can form your own LLC online for, yourself without paying me to do it. That doesn't include the operating agreement, which I think is the most important part of forming an LLC. So generally, people will hire an attorney to do it. And then, as I mentioned earlier, the annual fees are $500 a year. I think of that as another form of insurance. So it's an additional insurance premium that you're paying. It doesn't mean you're not going to buy insurance to protect your property. It just means you have additional insurance because you have this LLC as a protective measure protecting your personal assets. Um, and as with a partnership, sometimes the banks can be a little squirrely about financing any uh, borrowing that you want to do with regard to the LLC. But with the addition of personal guarantees, it's usually not a problem. Um, I will see these more and more in all types of businesses, but particularly with real estate, because folks are, they've built up a nest egg of their own that's outside of their land, whether it be cash or investments, or in particular their retirement accounts, and they want to protect these from any potential lawsuits. So they'll put an LLC in place to own some of their land or all of their land. Um, what else did I mention? For those of you in Massachusetts, Chapter 61, A or B, is out there. You're probably familiar with it. Um, you can have an LLC or a partnership and use these chapters to reduce your property taxes. So that's just something to keep in mind. It shouldn't be something that stops you from forming an LLC or a partnership. You can still use Chapter 61 and its A and B. Um, you have to be careful with transfers. As long as you're transferring within the family, you usually don't have to worry about rollback taxes, but it's something to think about. And so I can get into more on that if there are questions about it when we move forward. Um, and then estate tax planning isn't really a part of this discussion, but it's always lurking in the background, at least in Massachusetts. As I said before, a lot of states have figured out that they want to keep their people that are aging, and they'd like for them to, sort of stay in that state and pay income taxes and property taxes and sales taxes or whatever they have, rather than having them leave to go to a state that doesn't have estate taxes, like Florida or Connecticut or other states. Massachusetts woke up a couple of years ago and increased their estate tax exemption to 2 million. It used to be a million, which was really, really low in today's world. And 2 million, I think, is frankly still quite low, but it's better than it was. And for those of you in Massachusetts, that 2 million threshold means that the first 2 million of your estate, be it land or cash or anything, is exempt from estate tax. If you're over that, so if you're at 4 million, the excess over 2 million will be taxable in Massachusetts when you pass away. If you have a surviving spouse and you leave it to your surviving spouse, there is no tax regardless of the size of your estate if it's left to the surviving spouse. But so that means that the $2 million exemption generally kicks in when the second spouse passes away. Um, and there's a lot of ways around that. Trusts, which we talked about, can be structured to effectively double that estate tax exemption to 4 million in Massachusetts, depending on what language you have in the trust. In addition, you can gift to family members multiple generations down to remove land from your estate. But as I said before, the basis in land that is gifted is going to be your basis, not the date of death value. So that isn't often the best option. Um, LLCs that own land, we can gift interest in LLC land a little bit at a time to slowly get property out of our states. So that's an option as well. And lots of other ways to reduce the estate tax, not least of which is the whole focus of this series, which is conservation conservation planning, which, in addition to preserving the land, has some huge income tax and estate tax advantages. So I think that's something to really keep in mind, particularly here in Massachusetts with all the tax advantages that are available. Um, and then in closing, just sort of a couple of mistakes that I, sort of thought of. The main one for me is the bottom one, waiting until death to sort it out. It's too late then. So, you're leaving the family to sort of figure out, what did mom or dad want to do? How should we divide up this land? Are there people that want to operate the family land, and others that don't and would prefer to have money? Um, that can work, but it's better if it's planned ahead of time. If you just, do a simple will and leave everything to all the kids and let them figure out where to go from there, it's a lot harder and can breed some very difficult situations for the family. Um, it's important to, I think, in today's litigious world, consider an LLC if you've got any kind of family business operating on the property. Um, and then the other one that I've run into a lot is, leaving everything in equal ownership without some delineation of who's going to make decisions, how are we going to operate this land, what are our goals for the land and our objectives. We can't really restrict too much what happens in the future, but we certainly can say, this is what I'd like to see happen, and this is why I'm leaving this land to you, because I trust that you're going to follow sort of my lifetime of preserving this land, of operating this land and caring for it. Um, I see you as, the stewards of this land after me, and all of that stuff. If it can be discussed and laid out in writing, I think it's really beneficial. And I think that the next generations will appreciate it because they can hear it from you rather than trying to sort of figure it out after you're gone. What would, mom and dad would have wanted here? Who knows? I mean, they never talked to us about it. So it's really important to sort of clear the air with that if you can. I have one other story that happened a few years ago. A fellow left a will and very clearly left two rental properties and some farmland to two nephews because he didn't have any children. And that was fine and everything was okay, except one nephew lived out of state and didn't really want to operate this rental property and certainly wasn't involved in the farmland. So the other nephew, who was local and was running the farm, approached the nephew out of state and said, well, I'd like to, buy you out, give me a number. And, so he dutifully got an appraisal and said, I'd like 300,000 or whatever the number was for this property. And the farmer said, well, no, that's outrageous. That's way too expensive. I'll buy it for 100,000. And so the non-Mass resident said, well, okay, well, I'll buy you out for 100,000. And the farmer turned around and said, well, no, it's worth 300,000. So, you get into these situations where, you know, everybody wants a good deal and it doesn't always work out that way. And if the uncle had left his specific direction as to how he would like that to be worked out, I think it would have been helpful to both sides of the family to know, to have some direction on what to do next. So I'll close with that and would love to entertain any questions.
Thank you, Peter. That's fantastic. Getting started as soon as possible, formalizing your wishes, making sure it meets your goals, being specific in those instruments, those are all phenomenal words of advice. So thank you. There are several questions that I'll start going over that were put into the chat. While I'm doing that, please feel free to add more questions. If you would prefer to just unmute or raise your hand, that's fine too. We'll go through as many questions as we can here. It's a wonderful opportunity to have access to Peter. So